This is District Judge Kathy Seeley, and Judge Seeley has been kind enough to address, this will be the third group of crosses. And was it 3 years on the bench?
Not quite. January will be 3 years.
Okay. But Judge Seeley has handled all the various kinds of hearings that we get involved in with our kids, and so she's quite experienced. And it's an opportunity for us to learn a bit about how the court works, what the judges really look for in these cases, and how we can maybe best, or maybe you could provide some direction or tips as to how we might best present ourselves in our court reports and etc. And before I turn it over to the judge, let's all introduce ourselves. Julie?
Julie Ward.
Karen Moran. Carol Kitson.
Susan Gallagher.
Katie Lawler.
Donna Sue.
Alan Stricker.
Brianna Knowles.
Cindy Holmes.
Okay. I will not remember that.
And then Margaret. And Missy.
Well, Bill usually gives me sort of some talking points. I think I stand up. I don't know how you want me to.
Yeah, whatever's comfortable.
And if you have questions, feel free to ask. We do really value the CASA volunteers in these DM, dependent neglect cases, because I obviously can't go out and talk to people. You're kind of my eyes and ears out there. So it is a real important job that you do. And one of the questions that's been raised often is that when you go to the hearings, pretty much what we seem to hear about is the parents, and that's true. The hearings seem to be pretty parent focused instead of necessarily hearing about the kids as much as you would like. So even though you represent the kids' best interests, I guess that could be kind of frustrating. But I tell people that the courts, the law tells us that natural parents have a fundamental right to parent their children, and it's something that the courts take very seriously, and we have to go through all the procedures and give them basically every chance that we possibly can to see if they're going to be able to be, at least to be able to minimally parent, to meet the threshold. And the goal is always reunification of the family. And so we work on that for a long time. Sometimes maybe people think too long, and then if that isn't working out, we look at what's going to be in the best interest of the child to try to move on from there. And I don't know, do you hear from people from DPHHS in your training? Do they come back?
Yeah.
Because I've been hearing kind of a bit of a change in their perspective, that they really, really believe usually it's better to try to reunify, that even maybe not the best natural parent is probably better than most foster situations. I don't know what you've been hearing. That's what I'm hearing when I go to training.
Yeah, and we kind of preach the same thing, that we talk about this minimum standard of care, or minimum sufficient level of care that is really what we look for in parents, that we don't expect perfection by any means. And if they're good enough and they can keep the child safe and provide the basic needs, then we really can't require a whole lot more.
Right. Because sometimes, not very often, once in a while as a judge, I start getting the feeling that we're creeping into making these people into better parents. That, that we might have gone where we've met the basic threshold and then we're starting to tinker. And I know that they're usually not particularly good parents, but it's just an observation from my perspective.
So how do you define the basic threshold?
Well, I don't really define it. The experts tell me if they're going to be able to meet that threshold.
Yeah, but it strikes me that you're the person who determines if what they're calling meeting the basic threshold is true or not.
Well, you're right, but it's not like I have a laundry list. It's I would have, usually there's some kind of therapist that's been working with the parents, and they'll tell me, mom has got the intellectual ability, she may have some emotional problems, she may have an addiction problem, but I think if she keeps with her treatment plan, she can do this. Maybe Bill would say, or the CASA, that I've been in the house, the kids are old enough, they really want to stay, but there's problems, we had an issue, I don't know, maybe a relapse, or there's kind of dirt in the house, or there's somebody there in the house with mom that we don't think should be there. And it does get to be kind of gray and squishy, but if everybody seems to have a bit of a consensus that I have rarely, in fact, Bill might tell you, there's one case where I denied a petition to terminate, and we'd gotten to that point initially, and that was where we had the CPS worker and the CASA and I think Bill saying we need to terminate, but we had a couple experts saying no, these parents haven't been given enough of a chance, we need to work with them some more. And in that instance, yeah, I have to make the call, and I made the call. We aren't going to terminate right now, and what, about a year later, we terminated. So
Well, yeah.
but we gave them every chance to try to.
Okay.
So it is. It's not all that
It's
black
not
and white.
definable, really.
But usually, most cases by the time we get to that, I've rarely had any disagreement from anybody about where we're headed, other than the parents. Obviously, they might disagree, and sometimes even they don't really. I mean, so.
Can I ask if, with the best interests, at what point does that rise, to the top of the ladder? It seems like we spend a lot of time establishing that the parents are not in a position to parent, or the parents are not capable of, or the parents have not invested in the process of meeting the treatment plan goals. And is it only then, after we've established the parents are not in the ballpark with us, that the best interest question predominates?
I would say probably yes. I mean, we're always supposed to be looking out for their interests, but we're trying to reunify, and we're trying to reunify, and we're trying to reunify until some trigger point hits where we just decide. And the interests are always in there. We have the time limits where we can't, although we it almost seems to me routinely say that we're going to make an exception here and go beyond some of those time limits. But I don't know. That's another thing I don't know if I can tell you black and white. They're always supposed to be, we're always supposed to be looking at them. And I want something that we've started doing more since I've been on the bench. I don't mean that I instigated it, but they started giving me a little bit more updated pictures of the kids, because I don't usually see the kids, and they're just sort of a little person with a blob over their face that I hear about, but I don't see them, and it's kind of nice to see a picture of them a little bit more than just.
Who gives you that?
CPS usually attaches it to a report. And that's kind of a nice thing, because I often don't meet these kids at all. And then another question that has come up is CASAs have wanted to communicate directly with the judge, and what are the rules about that? And normally you can't communicate with me unless everybody's present. There's a statute about you can write reports to me, but they still are going to be provided to counsel. You can't really have secret contacts. You are my eyes and ears, and it's come up a little bit in court if, and it's usually the parents' attorneys, but if they start feeling like you're not being fair, you're kind of getting slippery about all that, they'll start complaining. I mean, it would be a reason that you might feel attacked or something in court.
Do you hear much complaining from either side?
Not too much. It's just more if they start feeling like, I think it's more the parents, well, I really trusted Julie. She's my buddy, and we were getting along so great, and well, now all of a sudden she's saying, yeah, we really ought to terminate parental rights, I don't. And sometimes I think the attorneys may, I don't know, maybe believe too much of what a parent tells them, or maybe I don't know. It's never been a huge issue.
Mm-hmm.
But, let me see. Oh, and then it says, children must be given an opportunity to appear at permanency hearings. What are your thoughts about children appearing at those proceedings? Really, they've rarely had them come to the hearings. I know the statute says they're going to come, but they usually tell me why. Hi,
I'm sorry.
Linda.
Excuse me.
Oh, no problem.
The children choose not to, you think?
Well, I'm not sure that the children really choose. A lot of times, the social worker gets up and says Sally's in school and this would be very traumatic for Sally given what's happened to her, or
Sure.
you know, Johnny's only 4 and he doesn't understand what's going on and it would just be stressful.
Sure.
And so a lot of times that happens. And I'm not sure the statutes really, when I read the statutes, they actually kind of talk like I'm supposed to talk in a age appropriate manner with any child and, you know, how's it going there? And I'm not real comfortable with that. I don't really like it. I think it is really stressful for kids. Teenagers will come in and say something and they seem more comfortable with it. Even a lot of times the teenagers don't come though, actually, but little kids, I don't know, they seem really, really stressed out when you kind of have them in there. So I don't know what you think about that. Why is that law, why is it in effect like that? Do you think?
Well, yeah, it just applies to the permanency hearings, and I guess that's, you know, the permanency usually occurs, well, it has to occur at 12 months, but it often occurs after termination, but before there is adoption, guardianship, or something that would happen that would cause the case to be dismissed entirely. And it's kind of a critical time for kids in terms of this is their future, and they ought to maybe have the opportunity to weigh in when the permanency plan is being addressed for them. So I guess that's why it's there.
Yeah, I don't know. It's been that way since I've been on the bench, but it's real awkward. I've had kids that are 8, 10, 12-year-old sisters there all clinging together and kind of getting teary-eyed and disagreeing with what everybody's recommending that should be done. And I don't mean that it's bad to have them there, but it's traumatic. For me, no.
We'll consider your feedback.
And then what kind of information is most helpful in our testimony and written reports? It's just, as I say, it's just pretty much what you've learned from the child. What they're wanting, what their needs are, how are they adjusting to the situation. And I do like recommendations after you feel like you are comfortable enough with knowing what's going on. So that, again, I just, anybody who can give me more information, that's a good one. So.
You know, there's, I know with some of the judges, what they're interested in hearing is how we weigh in with respect to a disposition of custody, and not so much on a visitation plan, particular services, and they've always chosen just to leave that to the department's discretion to figure out what's best in that regard, and don't incorporate that into a ruling. And do you want?
I don't mind hearing that, and I will tell you, I'm not controlling, maybe as much as I should be, what comes in at those hearings. The deputy county attorney who's representing the department is usually kind of deciding who's going to testify. I really appreciate it at times knowing, for example, when you think there needs to be more visitation, that sometimes it seems to me that the parents' contact with kids is really being limited. And the department doesn't really like to necessarily hear from me or from you that, you know, this isn't enough. I don't see how we're going to work this out when they're seeing this child for an hour in supervised visitation. So I'm open to it. And I don't know if you talk to the deputy county attorney before the hearing and kind of ask to say something, or if you just, because I will admit to you, if you're just sitting out in the audience, I don't normally say, hey, what do you think? You know, if they don't say, we're going to have the CASA come up. So maybe if you have a strong feeling, it would be a good idea to at least mention it to the county attorney, or maybe raise your hand in court and say, I have something to offer here, and then we would have you sworn in, we could have you testify.
So that's okay.
It's okay with me.
So it's not totally up to Tara then?
Well, see, we tend to kind of leave it up to her, but I'm not saying that it would necessarily have to be. And I don't think she'd get all, I don't think she'd be, unless you just shocked her with something. This is the most crazy thing I've ever done. But I mean, I don't think she's going to
No, we
want
do have an understanding between us. That
Yeah, and that's what, see, I'm not real
surprises.
privy to how you communicate.
The other person is like Carolyn Clemens, who represents the child.
Right.
Sometimes she will want to call the CASA.
That's true, because they might really want to express what the kids want to have happen, and maybe you can really support that, or explain it, or tell me what's going on. And there's a statute that says that the GAL's report or testimony regarding the report is not hearsay when it is used to form the basis of the GAL's opinion as to the best interests of the child. Can you explain why we are given that latitude? I don't know if that makes sense to you. Normally you can't just come into court and tell me what other people are saying. I read that as they're recognizing that you're experts of a sort. Experts can tell me why they're making their decision, what they're relying on to make a decision, and I believe that that statute is them recognizing that you do have expertise, and that's why they let you do that. And then I just had any tips on testifying, and I didn't. I've copied off a few things that we used to tell people who are going to be testifying just in general, and it's just, and I don't, I feel kind of odd telling to appear and professionally, on the witness stand and off. You don't know who's out there watching you. You might be amazed, and I haven't had it with a CASA, but some party coming in and saying, hey, I saw her out in the lobby, she was talking to so-and-so, and she was saying something really loud about whatever, and speak clearly, speak into the microphone. If you've been in my courtroom, it's big, it's hard to hear, it's a chronic problem. Answer verbally, don't nod, don't just say or something. Listen to what they're asking you. Listen to the question, and don't feel like you have to agree with somebody just because they say, isn't it true that Johnny would be much better off back home with mom and dad? You don't have to nod and say, yeah. You need to say, or if you want to explain, you can even say, can I explain? And they might cut you off, but then at least that informs Tara or me that she needs to ask you something later on cross. And that's, if somebody objects, stop talking, let me rule. If I say the objection is sustained, that means you don't answer the question. If I say it's overruled, then you can go ahead and answer the question. And we can tell you that, if you're nervous, it's not a big deal. If you make a mistake, you need to clarify that. You don't want to just sort of think, maybe nobody will notice that I misstated something. I mean, really, nobody's going to hold it against you that you made a mistake, but people will start to hold it against you if they unearth later that you said something that was wrong, and if you say, well, I was wrong, I didn't realize, that's fine. But if you well, I just didn't really want to admit up there on the stand that I was confused or something, that's not good. Know the case, review things before you get up there. It drives me crazy in court and it doesn't happen in these cases as much as like police officers will come into court all the time and they haven't reviewed their report and they can't remember what happened, and so we're all sitting there trying to drag out of them, look at the report, read the report, so. And if you think someone's asking questions that are objectionable, just maybe pause a little bit before you answer to give Tara Harris or somebody an opportunity to jump in there. And the final point, and everybody knows it, is just tell the truth. Nothing but the truth. That's all we want to know. And if you don't know, if you really don't know, just say you don't know. So, but any other questions?
Suppose you had a friendship with a public defender who was handling one of these cases. Would you want to state that at the outset? Is that perceived as some kind of conflict of interest?
If it's really a close relationship, maybe so. I mean, it wouldn't be a bad idea to let people know. And you work with Tara Harris, I'm assuming, so you might want to say, I'm pretty close to this person. All of these people kind of know each other after a while. There's a lot of relationships. I mean, we're all very formal in introducing everyone, Mrs. Bill Collins, Mr. Collins, but I've heard this all before. We kind of get to know each other. But if it's something that might shade how you're looking at something, you should probably tell somebody.
I would think the attorney would probably want to
The
put
attorney
that out
would
in the
probably take care
open
of
as
that
well.
Sure.
at the beginning.
I mean, if it's something in the back of your mind that it might impact how you feel about this case, if that person tells you something that you're gonna believe it more than somebody else or something like that, it's,
Or just that somebody else might have a perception of
sure.
something.
And I don't know, I'm not saying you have to blurt it out, you have to talk to somebody before court and let them know. But if it came up, you could be asked about something like that. I mean,
Ask Bill.
Yeah, there you go.
Oh, Bill.
Have you been to court? Have you gone and observed or anything? Or?
Well, and I was gonna ask that, would there be the opportunity to go and observe if Akasa is testifying, just to,
Yeah, we've had Mikasa sit in, and I usually get permission particularly from the attorneys representing parents, that's not a problem for them. You know.
okay,
So it is, these are really private matters. And
So do we have to let you know that we want to, and then you'll check on it?
yeah, I got the schedule, the court schedule, so I know what's coming up, and we wouldn't want a whole crowd in the
No.
courtroom at one time, but a couple at a time, sure.
Yeah, the Casas haven't really testified all that often in court.
But we can see how the thing goes.
Sure. No, it's not a bad idea at all.
Yeah, it seems like, terminations, we generally always.
Terminations, you're almost always going to hear.
Yeah.
And as I say, there's been a few times, I think you've
Yeah.
commented on visitation for the parents and that
Yeah.
sort of thing.
So who relays the information that we gather then?
Usually you write a report.
Right.
I would think if it's, and then that could come to me, but copies would go to everybody.
Okay.
And
so
I
you're
don't
just-
know, again, what your training is on that. I see reports in quite a few cases. Sometimes I don't really see anything in writing.
So you're just going off the report, you don't need us to reiterate the report?
Well, not
Yeah.
necessarily, unless somebody wants to have you
Sure.
testify. I mean,
Sometimes what happens is that, like, if it's Carolyn representing the child and Tara's representing the department, that they will wait until towards the end and then make a decision whether they're really gonna need to have testimony from the cops or not. And it's just how they gauge how the case is going and make a decision kind of on the
But
fly.
our reports, our information
Yeah.
is being considered though, even though
Yeah.
we're not.
oh yeah, if there's a report,
Oh, okay.
at least I certainly read the
Yeah.
reports.
Yeah, the judges.
I'm assuming that all of these DN cases are judge, no juries involved?
Right.
Okay.
so it sounds like we may not testify, or may, typically, probably not, until maybe towards the end. But I thought I heard earlier in one of these sessions that we should still be there.
Yeah.
The cost
Okay,
of-
all right, I just
Yeah,
want
you
to make
should.
sure I'm clear on that.
Yeah, the
Okay.
statute actually says that to attend all hearings.
I thought that's what I heard, okay. All right.
And they reflect in the record always, they'll stand up, Tara Harris, usually the deputy county attorney, will announce who's present in the courtroom, and CASA is one of them they name
Okay.
for the record that you're there.
Okay, all right, so those are closed hearings then, I'm gathering?
Yeah,
Okay,
Yes.
all right.
and like I say, and I don't want to terrify anybody. I mean, if you're there, you could be asked, somebody could turn around, it happens, they turn around and say. No, but I haven't seen that much. It's the Child Protective Services people and things. So doing a lot more testifying.
I'm married to an attorney, that's why I'm afraid.
This is different.
Yeah.
Well, they really usually are not. It's not usually too
It's
much.
different outside.
Lots of things are different outside here.
Anything else for the judge?
All right. Well, again,
Thank you so much.
thank you.
you.
Like I say, your service is very important.
Thank you.